Good evening. You're watching The Digital Age, and I'm James Goodale. The Scooter Libby trial is about to go to the jury, but has it been worth all the cost? Think of the damage it's done to the press, for example. Is the Scooter Libby trial worth it? That's what we're going to discuss tonight. And here to discuss it with us is Bob McGuire, an attorney in private practice who has been the police commissioner of New York and has been a defense lawyer and a former U.S. attorney. Most qualified man we could find in all of Manhattan. And George Freeman, thanks for coming by. George Freeman. George is the vice president and assistant general counsel of the New York Times, heavily involved in the Scooter Libby case from the vantage point of Judy Miller, knows all about it. Well, we're about to go to trial. The defense rested. Were you surprised that the defense didn't do more? Bob McGuire?
I was not. Ted Wells, Libby's lawyer, is an extremely accomplished defense lawyer. And I think he recognized that the weight of the evidence against Libby, just in the context of whether or not he told the truth in the grand jury and to the FBI, was pretty overwhelming. And I think he's going to try to pick holes in the government's case and argue other things rather than subject Libby to the cross-examination of Pat Fitzgerald, the prosecutor.
George, this trial has consumed a good part of your life for 2 years. We were looking forward to seeing the vice president on the stand. We were even looking forward to see Scooter Libby on the stand. Were you surprised that we didn't see the two of them?
I was certainly surprised that we didn't see Libby, the defendant. It strikes me that given the case the prosecution put on, I would have thought that Libby, who's obviously a very, very smart guy, would have been given a chance to create a rapport with the jury and to give his side of the story. This way, they really haven't had much of a defense case at all. And if the jury really views the case as the narrow case that the prosecution has portrayed it as, did he lie or didn't he, I think he's in very tough shape. The defense strategy, I would have thought, would bring as much extraneous material in as possible, particularly focusing on the fact that this was not the first leak in the case, in which case the jury might think, why is this all so important? But I think with the short case they put on, I'm not sure they've gotten that point through, although I'm pretty sure we'll hear about it in closing argument. But I was surprised, yes.
Well, we got to explain a little bit, of course, to the audience may not be as up to date in the case as we are, that the case started off as an investigation of a leak. And in the leak leaked the name of a CIA agent. The prosecutor then went beyond that, finding really that there was no crime, and the case became a perjury trial. And as George points out, it's really a case of whether now Libby told the truth. And George's got an interesting point in terms of making a connection with the jury. Libby's testimony before the grand jury was played out. Do you think that does him any good in terms of his relationship with the jury? It was played, what, George, 7 hours or something?
I think so, yes.
Yeah. Were you there when you were there at the trial?
Not that day, no.
You have been at the trial, though, have you? Yeah.
I don't think you can answer that unless you sat in the courtroom and listened to the grand jury testimony.
Oh, would you do that?
Well, one theory.
Well, let me ask you this. Let me ask you this, and you can answer the question.
Sure.
Would you have done the same thing that Wells did with Libby and not keep him off the stand?
Yes. As I view the trial and as I viewed the cumulative amount of evidence coming in, several government officials who indicated that Libby had talked to them about Valerie Plum, as well as the reporters on the flip side, Russert categorically stating that Libby never spoke to him about it, Judith Miller and Matt Cooper both saying that he had spoken to them about it and tried to persuade them about it. I think that from a defense standpoint, to put him on the stand and subject him to cross-examination would have been a really risky thing. What Wells is going to do is argue, you've heard his testimony. He spent 8 hours in the grand jury.
You heard it over the, yeah.
You heard it because they did an audio in the courtroom. But from reading the news clips, Jamie, what happens in these trials is the jury is going to assess his credibility when he was in the grand jury. And apparently, he was less than confident at the tail end of his testimony.
I don't have a chance to look at his demeanor or look at his face. George, one of the interesting comic things that apparently happened in the trial on the last day before they made their closing argument was was on Valentine's Day. The jury came in with T-shirts. I can't believe this happened. Every juror came in with a T-shirt with a great big heart on it. I don't know, and it may even said, "I love you." There was one juror, I think was at the Metropolitan Museum or something like that. That's her employment. Didn't, but anyway, can you imagine all those jurors coming into a jury box with a T? What is that all about?
Well, I think the jury must be bonding amidst all the pressures of their role. I wouldn't put any significance on it. They didn't say where they got the shirts from or which juror had the chore of getting this whole project together. But you know, a jury trial takes on a life of its own, and I guess the jurors thought they ought to have some fun. More power to them.
Okay, and what's going through these jurors' minds? You don't screw around like that unless you're communicating something about the trial. They said, "We're doing it, Your Honor, because we love you," and the judge apparently, "Please don't do it." But what does that say about the jurors' state of mind here?
I'm speechless. I've not heard about this before.
Oh, I just brought this to your attention?
I did not know about it. I have not heard it in the context of many other jury trials that I've been affiliated with, and it would be a little off-putting if I were on either side, quite frankly.
Well, let's ask ourselves now what we think the jury's going to do. Let Bob think about the answer to that question in light of the fact they're all wearing T-shirts. What do you think the jury's going to do, George?
I think, if I had to predict, I think they're going to convict. But I think it's far from clear. I think the evidence of the prosecution was put in pretty straightforwardly. I think there are three grounds in which the jury can come to a defense conclusion. One is, you know, on the merits, that Libby didn't lie or at least didn't intend to lie. And I think that's the least likely possibility. One is that, you know, there's enough reasonable doubt around the edges. The defense has certainly tried to put that in its mind. Maybe it'll work. To me, the more likely scenario is that the jury might conclude kind of jury nullification. Was this really worth it? Did he really do something really bad? Or is what he did something that's done by witnesses in Washington regrettably all the time? You know, as you said, this started out like an important case of whether someone outed a CIA agent for political means. And it ended up in what I'd call a ho-hum, you know, small Washington lie case. And it may well be the jury will decide it wasn't worth it and that therefore they will acquit him. Not necessarily on the narrow grounds that they're being asked to judge, but on a broader grounds that it's simply the punishment doesn't fit the crime here.
Well, let's pick up on that theme, which is the central theme of this program. Doesn't Patrick Fitzgerald have better things to do than bring a case like this, which starts off with an important matter? Because there is a statute out there that says if you leak, it's a death penalty. He gets to the end of that, and he could have folded up. I've done my job, but in the course of finding that out, he sees that Libby has perjured himself. And George says, hey, it's a small lie. Do you think the jury will think it's a small lie? What do you think? Do you think it's a small lie?
No, I don't.
You don't think every lie is a lie. Doesn't make any difference.
No,
You're
not every lie. Not every lie is a lie, but perjury in a grand jury. I mean, the Martha Stewart case comes to mind. There was no underlying insider trading case that they could prove, but she perjured herself before the SEC and in the grand jury. So you have the same situation here. You got to go back in time, Jim. You have to look at the beginning of this. This was an effort, arguably, to out a CIA agent whose husband had really taken away one of the underpinnings for the justification of the war in Iraq. So it was a big deal in Washington. Fitzgerald was only in the case as a special prosecutor because Ashcroft recused himself, because he was close to the White House.
Just tell us how the special prosecutor is appointed.
The special prosecutor was appointed in this case because John Ashcroft was, in effect, the attorney for the Bush White House. And so there's been iterations of how they're appointed, either by judges or, in this case, Jim Comey, who was the assistant attorney general, the number 2 guy under Ashcroft.
He was in charge of him.
He was a career prosecutor. And he appointed Pat Fitzgerald, who has a stellar reputation as a apolitical career prosecutor.
Do you know Comey?
I know of him, yes.
Yeah.
I came out of the same office.
Yeah.
Comey had a very good reputation. He appointed Fitzgerald, who was the U.S. attorney in Chicago, having served in New York City as an assistant U.S. attorney. Very apolitical guy. He's looking at a possible violation of the National Espionage Act as well as the National Intelligence Identities Act. These are serious potential criminal charges. You say he came to the end and decided there was no violation. I argue he was obstructed because people committed perjury in the grand jury. He, to this day, doesn't really know whether the White House was engaged in some kind of conspiracy. In the middle of it all, he finds that Scooter Libby, a special assistant to the Vice President of the United States, lied to an FBI agent fairly baldly and basically categorically lied before a grand jury. I don't think that's a small lie or a white lie or something that Pat Fitzgerald, irrespective of whether there was an underlying crime, whether he hasn't got an obligation to pursue. And I slightly disagree with George. I think this jury is going to be charged by Judge Walton very narrowly, and they're not going to be looking at the broader political significance.
Well, they know, but okay, well, we'll get
and
George to respond to that.
I think they're going to be told, if this guy lied, if he lied as to a material matter in the grand jury, you should convict.
Okay, let's pick up George's view of the jury. We've got a Washington, D.C. jury. We got one juror from the Washington Post. I want to ask, what's the juror from the Washington Post doing there? But Bob says they're going to be charged narrowly, but this jury knows what's going on. It doesn't make any difference if it's charged narrowly. He knows it's part of a great big political thing.
That's my point. I mean, I agree and disagree. I mean, I disagree. First of all, I mean, I'm not saying that a lie to a prosecutor or a grand jury is unimportant. What I'm saying is that the jury, in the greater scope of things, if they think about the broader context, might view this is the way Washington, for better or worse, lives. Why is this the case to bring it forward? Why is this the case to punish so harshly? So I, you know, that's just an iteration of the same question. But the question with Fitzgerald, where I think, you know, I understand both sides. Fitzgerald, when he indicted, gave a speech that lying in the course of an investigation is simply unacceptable, and the government can't carry out its role of justice if people lie to it under oath in those circumstances. And I fully understand and agree with that. I also think Fitzgerald is a very able guy, and we dealt with him. He's a very professional and very obviously very good lawyer. On the other hand, this did start, as Bob says, as a very serious inquiry as to the Agents' Identities Act, whether someone outed a CIA agent. At some point, and we don't know exactly when that point was, Fitzgerald learned two things. One is that an indictment wouldn't be on those grounds, but would merely be an obstruction of justice perjury ground. And the second is that the target who he was chasing, Libby, was not the first leaker. The first leaker was Armitage to Novak. And when those two things happened, one wonders why he couldn't have put the yellow or even red light on, rather than A, get into a confrontation with the press, which sent my client to jail for 85 days, and secondly, continue spending taxpayers' money in the course of this trial that's ongoing now. And I think there's a lot of questions as to whether he used his discretion properly at the point he learned those two things.
I think that's right, George, but I think you have to look at a timeline, because it's not clear to me when he first learned about Armitage being the leak to Novak, and whether that preceded or came after his interview, or the FBI's interview, and a grand jury interview of Libby. So I think that's an issue. And so it could be that he hadn't made any of these critical decisions. And I would argue in his behalf, in a case like this, it's not clear that there weren't parallel efforts being made to out Valerie Plum and discredit Joe Wilson, her husband. It could have been that Armitage, as you know, who was not close to the White House. He was a State Department guy. He was a Colin Powell guy. And he's talking to Novak, but there were other people, namely Scooter Libby, trying to do the same thing. So it's very difficult to figure out who's doing what to whom down there. And I don't know, until we really get a retrospective on this from Fitzgerald or the grand jury proceedings, exactly what the timing was on all this.
Let me just say, Jim, that I think what we do know, though, and although we haven't yet gotten all of Fitzgerald's papers unsealed, even the papers that were filed against Judy Miller, we haven't seen all of those legal papers yet, and there's efforts now to get access to them, and there's no reason in the world why access shouldn't be given at this late date. But we do have reason to believe that he learned of Armitage's first leak in interviewing Novak, which happened early on, certainly happened before Judy Miller went to jail. And so my question is, as difficult as it was to have a client going to jail, it's far more difficult to understand it now that we know that he knew who the first leaker was before she had to go to prison.
Right.
And it really seems to be unjustifiable in that regard.
But it does beg the question of whether, once he learns Armitage leaked to Novak, does that cause him to wrap up this investigation? It raises a larger question, by the way, which is the boundaries of special prosecutors, which is another whole issue.
Yeah, no, but I think the issue of what special prosecutors do or don't do is part of what we're talking about. I think what George is saying is that the story broke. We got to make it clear to everybody. The story broke because Bob Novak ran a story in which he said that the CIA had sent a gentleman whose name is Wilson down to Niger, and his wife worked at the CIA. Did he mention the agent's name? I can't remember.
No, I think he just said the wife.
Just said the name. Okay, so that was the whole story as far as we all knew. Now, that's what he
sent Joe Wilson, a former ambassador, down in Niger to find out if Iraq was trying to purchase uranium.
Yes, thank you.
Towards nuclear weapons.
Yeah.
So it was a major underpinning for the justification for the invasion of Iraq.
But his job was to find out whether that leak was somehow criminal. So once he finds out who the source is,
no, he knows there's one source leaking to one guy.
Yeah.
You know, and this gets back to the special prosecutors and what their parameters are, what their boundaries are. He doesn't have to believe necessarily at that point that that's the sole leak, the only leak. There might have been other conspirators. It might have been a joint effort in the White House and the State Department to leak Valerie Plum's identity. And that's the difficulty with something like this, where you have a broad-ranging investigation, and it's not clear even to Fitzgerald at the time, probably, whether that wraps it up. One leak, one reporter, one leak, that's the end of it.
That's a fair point. At some point in time, he decided there was no violation of law, because he then went back to Comey and said, now I want to expand my authority. Special prosecutor is appointed to do special things. In this case, to find out the leak. He finds out the leak, finds it doesn't violate the law, and then he goes back and says, I want to now deal with perjury. So the question, I suppose, before him at that point in time is, does he just act as a special prosecutor who's got to go out, got to find everything, or does he balance at that point in time the value of proceeding with that investigation against the harm that it's going to do to the press? Is that a fair way to put it?
I think it is. I think it is. Now, the question that Bob's raising, which is a fair question, is if he didn't go against the press, if he didn't push the contempt finding as far as he could and get all the reporters to testify, could he have continued the investigation? Would he have had enough evidence to continue the investigation that he then wanted to pursue? But I think the question you raised, Jim, which I agree with you, is that it really isn't worth the cost. I mean, the administration after administration in the past have not done what this administration, what the special prosecutor have done, which is really get into a battle with the press, confront the press, get into these confrontations, because no one, neither the press side nor the administration, and certainly not the public, there's no good that comes of this battle. You know, in the Pentagon Papers you were involved with, there was the same battle, and that hasn't been repeated by any administration since. So what is the gain, or is the gain in this particular case, a perjury indictment against a tertiary leaker, worth the confrontation that is going on and has gone on, including jail time of a reporter, in aid of this investigation? And I think it's a balancing act, but to me, the answer is clearly no.
Is it worth it?
I think it was worth it only because you have to deal with the fact of what Fitzgerald knew when he knew it, and I don't think he knew in advance that he was going to have this contentious issue with the press and with Judy Miller going to jail. Here, you don't have a national shield law, as we all know, so reporters are susceptible to being put in a grand jury on major cases like this. There is a balancing act. The prosecutors try not to do it unless there's no other way of getting evidence. In this case, nobody else knew the facts but the individuals who were leaking and the reporters to whom they were leaking. And so you ended up with this problem. In retrospect, I don't believe the trial was worth it in the context of the First Amendment or the press-prosecutor relationship. In the context of law enforcement and making sure people do not perjure themselves in a grand jury and lie to FBI agents, it was absolutely worth it.
Is law enforcement more important?
I think Bob's last statement is a fair summary, and so it depends really what context you're looking at. In the end, I think it wasn't worth it, but certainly, I mean, the value of having government officials speak truthfully under oath is an important value. I'm not doubting that. Whether he could have made the point without sending reporters to jail and a parade of lawyers on the witness stand is a totally other question, and I think the answer to that is it wasn't worth that.
All right, so now you're a prosecutor again. You have a broad view of society, and you are able to raise the two questions you raised for yourself. I've got to think about impact on society with respect to relations to the press. I've got to think of my role as a prosecutor and the obligations of a prosecutor. They have a role to play in society. Two different roles. Do you come out the same way Fitzgerald did?
I guess I would have been a little bit more nuanced in retrospect about pushing the Judy Miller thing where she went to jail. I would have put reporters in the grand jury. I would have had a judge attempt to coerce them to tell the truth and to testify to what only they knew was told to them by these government officials who might have been committing a crime. But I would have tried every way possible to avoid a real conflict with the press whereby Judy Miller ends up spending 85 days in jail. I don't know whether that could have been done, but that's where I think it really gets to a point where it's not worth it.
Was Judy Miller's testimony absolutely essential in this case?
I don't think it was absolutely essential because, in fact, if you look at the indictment, she's only mentioned, I think, in terms of 1 or 2 of the 5 counts. Obviously, she was an important player in the case. But the question is really, you know, we're setting up the balance vis-a-vis Fitzgerald. You know, it's as important to look at the balance vis-a-vis society. And from the public's point of view, while on the one hand, certainly important for government officials to speak truthfully, the attack on a reporter and her confidential sources really is bad from a public point of view, because the only way the public gets information about negative things, about criticism of government, whistleblower type information, maybe not exactly what was here. Here you had a high government official being the leaker, being the source. But I think it's really important to understand how the attack on this confidential source-reporter relationship in the end is not an attack on a reporter, but it's an attack on the public's ability to get criticism, to get negative news about corporations and about government, because those people willing to talk in those ways don't have the power to give their name to the story. They have to be confidential, or else financially or physically they could be very, very gravely harmed. And if we want that news to continue to go to the press and the public, the news that spawned Watergate, for example, we really have to respect that relationship. And indeed, you know, it's amazing, prosecutors do. When we went to the Supreme Court on the Judy Miller case, 34 state attorney generals signed on to our briefs, signed on to a brief supporting us, saying that a shield law was a good idea and it really wasn't necessary to take the actions against the press that were being taken in the case. You know, which shows that even prosecutors believe that they can do their jobs, they can do law enforcement without getting into this sort of confrontation.
Bob, going back to Judy Miller, there are 3 people in the case, witnesses, whose testimony conflicts with Libby's. And the key person is Russert.
It's far more than 3.
Well,
there are several government people who are categoric.
But you could, if you want to narrow it down on the reporter side, there are 3 reporters that contradict the testimony. And Russert's the key one.
Right.
And Cooper is a second one. And Libby and Miller was the last of the 3. Now, you could do this case perfectly well with the 2 witnesses and not Miller.
Right.
Would you agree with that?
Absolutely.
Well, if you were a prosecutor and you came up and you had the three there, and you don't need you would like to have the third one, would you exercise your discretion? I guess you would, from what you said earlier.
I would, but again, you're dealing with, after the fact, looking backwards. Pat Fitzgerald was looking going forward, not knowing all of this stuff.
Well, he knew that he had the testimony of those two reporters.
I think he could easily have made his case if Judy Miller didn't exist and was not part of this trial. So it's unfortunate that that happened and that there was a confrontation and that there was an incarceration of a reporter, because George was eloquent in summing up the need to have a relationship. But this is a different case. This is not a whistleblower. This is a high-ranking government official in the White House, basically arguably violating the National Espionage Act in the context, the political context of the war in Iraq, which is where there was no greater interest in this country than those themes. So we have to be very, very careful. It's unfortunate, I believe, that it ended up with this conflict with the press. But I don't feel badly under these circumstances, as distinguished from a garden variety case, that sometimes reporters really do have to reveal sources when senior government officials are trying to impact major political issues in the United States in arguably an illegal way.
Do you think Libby will ever go to jail?
I wouldn't bet on it. And I certainly would bet that in the end, and I said this the day Judy Miller walked out of jail, that Libby will go to jail, if he goes at all, for less time than Judy Miller served. And that might be as good an answer to your question as any. I mean, if this case was really about lying in government, why will she have served longer than he if he's found guilty?
Now, Bob McGuire is a noted political figure. Therefore, it's fair to ask him a political question. Will the president pardon Libby so he doesn't go to jail?
Nobody has a crystal ball on that. I disagree with George a little bit. I think if he gets convicted, and I kind of think he will get convicted of the perjury, I think he'll get modestly more time than Judith Miller, sort of 3 months, 6 months, or house arrest type thing, house incarceration. And then I think it's a 50-50 question as Bush leaves the White House, whether he pardons Scooter Libby.
We've come to an end. Was it worth it, George Freeman?
I think it wasn't worth it for the reasons we've talked about, and I think that the view I have on this case really changed when it turned out that Libby wasn't the major leaker, and that the first disclosure of this was a big deal by Novak, a guy who cooperated with the prosecution, who never stood up for journalist rights, by the way. But his sources were not Libby, and when that became clear, I think the spigot should have been turned off.
Thank you, George Freeman, for stopping by. We have less time for your answer. It has to be yes or no, Mr. McGuire.
I think it was worth it.
Thank you, Bob McGuire, for stopping by. And thank you for stopping by. And come back next week and learn more about the digital age. For the digital age, I am James Goodale. Good night.